હલો.
हेलो.
જી સર, આપણે લાઈવ ચાલુ કર્યું છે સર.
अच्छा, तो હું અહીંયા સ્ટાર્ટ કરી દઉં કે વાર છે હજુ?
જી સર, સ્ટાર્ટ કરી દો સર.
Okay. Um, Good afternoon, everyone. Today, the topic which is given to me is a legal aspect of the business. I presume that all of you can see my PPT, which is on the screen. This presentation is all about how to crack the Gset examination questions and the NET examination questions. Before starting to my presentation, I would like to tell you that in order to give the answer into the competitive examination, first of all, in the legal aspect, we need to understand what the act is all about and what is the objective of the act, what is the purpose of the act. So my presentation is divided into the three categories. Point number one, what is law? That is a first basic aspect of the law. Second, what is the syllables coverage as far as this particular uh, Gset examination and competitive net examination is concerned. And third is, which kind of questions they are asking as far as this competitive examination is concerned. So I presume that I'm going to the second slide, and this particular slide is display unit number 9, in which, as far as this GSET examination is concerned, there are it covers the Indian Contract Act 1872, elements of the contracts, then special contracts, Sales of the Goods Act, Negotiable Instrument Act, the Companies Act 2013, which is latest, Limited Liability Partnership, which is again the form of the company, the Competition Act, which is also govern the entire market, the Information Technology Act, IT Act 2000, their objective, main provisions, cyber crimes and the penalties, the RTI Act 2005, what is the objective and which are the main provisions. And the last is intellectual property right, and the this GST Act. So if you look at this particular course is divided into the two category. Above there is a mercantile law, all the law which is related to the commercial activity, then related to the companies, the act which is related to the companies, and last two acts is related to the taxation aspect of the business, right? So this is the entire syllabus, right? Okay, now before starting to our discussions, let me make you understand what is the nature of law and law of nature. If you look at every law and the legal rule has a two aspect. One aspect is the sanction, and the another aspect is enforceability. If you look at the uh, I'm not able to grab this particular PPT, yeah, blank dekhade છે, but every legal rule has a command as well as sanction. Command law has a two elements, one is a command and one is a sanction. Command means in order to control something, and sanction means legally the particular government or the authority has sanction for the punishment. So these are the two ways of understanding of the law. So the law is the combinations of the command and the sanctions. Now, if you look at the Indian legal system is concerned, in the Indian legal system, there are all the act which is right now enforceable across the land. As far as India is concerned, it is the mother of all the act is constitution. So we need to understand which are the provisions into the Indian constitution. Based on that, this particular act is enacted into the Indian parliament, right? So if you look at Article 14, it may be asked into the examination, it may not be asked into the examination, because the nature of the examination is a competitive. So it probably it may ask Article 14, which represent the equality before law. So the all the nobody, no person can above the law or below the law. All the persons are equal in the eyes of the law, right? In Article 16, which says that equal opportunity into the matter of public employment. When we are talking about the public employment, it is nothing but when there are government companies, when they are publicizing the uh, employment opportunity, then the equal opportunity to be provided. So the employment related rule, all the Apprentice Act in India, which is enforceable under equal opportunity into the matter of public employment, right? Protection under the certain act regarding the freedom of speech and expression, which is here the Article 19(1)(c), right? Article 21, the protections of the life and the personal liberty. So when the particular person is employed into the company, what kind of a liberty given by the law, that governed by the Article 21. Article 23 of the Constitution says that prohibitions of the traffic of the human being into the forced labor, right? Here, all the Child Labor Act, all the compensation related acts, all the payment of wages kind of acts, that is enacted under this, protecting the human beings under the forced labor. And that's how this particular 8 hours of shift into the company that is came into the force. Article 24, which says that prohibitions of the employment into the children's and the factories, under which in the Factory Act 1948, section number 27, which says that prohibitions of the child and the woman in the factories, cotton opening industries, which also take care of the health of the woman. So that is under this Article 24. Article 35, legislation which gives the effect to the provisions of this particular part. So the Article 35. Article 38, the state secures the social order and promotion of the welfare, all the welfare activities, whether it's canteen facility, whether it's a crash facility, whether it's the AC offices, or sitting arrangement at the production plant, all this kind of a facility which is considered as the labor welfare facility, which is under Article 38. Article 39, which says that principle of the policy can be followed by the state. When the state is enacting any law, as far as the labor and the regularization of the labor is concerned, then there are certain principles to be included according to the Constitution. So that is given into the Article 39 and Article 39A, equal justice and free legal aid, and etc. So this is just information that where this particular, what is the genesis of this particular law. Then the Indian Constitution is a mother of all the law, and under the Article 14 to Article 39, all the law has been enacted, whether it's a labor law, whether it's a employment related law, whether it's a citizenship act, and those kind of, right? Article 5, which says that the citizenship of India, under which the every citizen has certain rights. So that is also all the Passport Act, Citizenship Acts, all the Aadhaar Act, that is being formed under Article 5. So I just want to make you understand that how this particular law is being enacted into the parliament, which is affecting to the entire length and breadth of the country. So when I was browsing the previous year paper, then mostly the labor legislations, then labor legislation, the ILO, Social Security and Minimum Standard of the Conventions Act 1952, one of the question is being asked into the Gset previous year paper, that the Social Security Minimum Standard Convention Act is a flagship program of the ILO, under which are the branches are there. There are 9 branches: sickness benefit first, unemployment benefit, old age benefit, employment injury benefit, family benefit, maternity benefit, invalidity benefit, survivor benefit, right? So these are the 9 elements which is recognized by the International Labour Organization as far as social security is concerned, and all the countries which are associated with the labor standard, International Labour Organization, they are following this. And sometimes the questions is being asked into the examination, and I have screenshot that particular question, that the social security minimum standard of the convention is related to medical care, sickness, unemployment, or all of the above. The answer is all of the above. So that was the particular questions which was asked into the previous the examinations. Then there are certain questions which is related to the banking sides also. As such, as far as the syllabus is concerned, there is no separate banking regulations acts are there, but even the RBI Act has not covered. But when I'm browsing the questions regarding this, preparing for this particular session, that time this particular questions which strikes me, that merchant banking covering the public issues, underwriting securities, is regulated by one of the following, then the answer is B. That is the Security Act, not the ICICI or guideline of Ministry of Finance or the RBI. Merchant banking, the answer is B. So that is also one of the questions which has been asked into the previous examinations, right? I'm not able to I don't know what's happened, but I cannot able to show you the graphical representation. I think can you see this particular PPT of mine? This particular PPT, Contract Act 1872. Can you see? I don't know. Here the graphical, whatever graphical representation I have included, it is not able to show in this particular PPT because I am streaming online. So all the graphical representation is not, I cannot able to show you. But anyway, the another questions which is related to the the government passes the MSME, that Micro, Small and Medium Enterprises Act in 2006. The small and micro scale industry came under the MSME Act. MSME Act is also not included as far as the syllabus is concerned, but since the nature of the examination is a competitive, sometimes they are asking these questions also. So one of the questions which I have clicked from the previous year paper, the concept of the small scale industry is introduced by the blank. Then the option is given: Industrial Policy Regulations 1948, Industrial Policy Resolution 1956, Industrial Policy Resolution 1997, or none of the above. The answer is D, none of the above, right? So that is that kind of a questions is being asked. Now, if you look at our second syllabus PPT, I presume that you can able to see that, right? So the first topic is Indian Contract Act 1872. We are trying to understand all the elements of the valid contract, capacity of the party, free consent, discharge of the contract, breach of the contract, remedies, and the breach of the quasi contract, right? So when we are talking about, let me touch upon this particular first act, Indian Contract Act 1872, which is into the hello. Hello. Can you able to see this, my Word document? Can you able to see the Word document as of now? Can you, can you able to see? Hello. Hello. I'm having some of the noises. Can you able to see this Word document? Can you able to see this Word document? Okay. Okay. I'm not getting the answer. Anyway, I'm going to the Indian Contract Act. Indian Contract Act. In the first slide, what we need to understand, what is the object and the purpose, right? So if you look at the object of this particular Indian Contract Act, so there are object of the Indian Contract Act is that to provide the framework for creating and enforcing the contract in India. And the purpose of this particular act is to establish the essential for the valid contract, including the capacity, consent, and the discharge. Capacity of the party they are talking about. Consent means both the parties is agreed upon to the contract, and discharge of the contract, right? So you know, in this particular PPT, it's just a blank. I don't know. I'm just opening this particular PPT online. So my you know, graphical representation, you are not able to you know, can you able to see this? Can you able to see this? See this graphical representation or not? Can you able to see this? Indian Contract Act object and that two circles. I'm not getting the answer. Can anybody speaks so that I can able to understand that whether it is visible or not? Okay. Okay, I presume that you are able to saying this Indian Contract Act visualization. So if you look at in the Indian Contract Act, there are what kind of things you need to understand as far as the Contract Act 1872 is concerned. Then here, when you are preparing for the examination, then Indian Contract Act 1872 lays down legal principles which where the contracts in India, it is regulate how the contract is being formed, enforced, and discharged, right? In this particular act, you are supposed to understand the key provisions of the Indian Contract Act, which regulate the commercial agreement, legal enforceability, and protect the parties who are involved into the contract, right? So if we look at this particular graphical representation, where in the blue color, Indian Contract Act, there are two bifurcations. In this, there are void contract and the voidable contract. If you go to the below that, then there is a remedies for breach of the contract. In the Indian Contract Act, discharge of the contract has a three element. First is a performance. On my left hand side, in a pink color, that is a performance about the contract. Then there is a breach of contract, means to break the contract. One party is agreed and another party is not able to agree. So that is a breach of contract, or another party is not fulfilling their commitment to the contract. And third is the mutual agreement, where the contract is executable. If you look at the Indian Contract Act in yellow color, essential of the valid contract. What is the minimum requirement of the valid contract? The first is a free consent. Free consent means both the parties mutually agreed upon to enter into the contractual agreement. There is an element called offer and acceptance. One party has something to offer, and other party, without any coercions, without any you know, forced, that particular party is entered into the contract. So that is a element of offered and acceptance. And there is always, since it is the Indian Contract Act, which means that there is a legal consideration backed by the law, and that law is Indian Contract Act, right? Before that, if you look at the Indian Contract Act, then this particular you know, this green color, capacity of the contract, this capacity of the contract, this has two elements: age of the majority, which means that a minor cannot enter into the contract, and the sound mind, which means that the person of normal intelligence can enter into the contract. So if you look at this particular representation, then Indian contract has three elements. What are the essential element? Parties capacity, remedies for the breach of contract, and discharge of the contract. So if you refer to the act also, or if you refer to the previous year paper also, then all the questions which is related to the Indian Contract Act 1872, which majority focus on this only. Right? I'm going ahead. If you look at the others, the same, I mean, no, here slightly I have modified this graphical representation where I have added these sections also in the competitive examination like Gset and NET. This particular sections may be asked, right? So if you look at in the Indian contract, that if you look at the discharge of the contract, they will not accept you, expected that you will remember every sections, but they can presume that you have some idea so that you can able to understand this particular section is related to this. For example, in the graphical representation, Indian Contract Act, if you look at the essentials of the valid contract, that particular section is section number 10 to 13 in Indian Contract Act. What is a legal consideration? Then in every act, if you read any act of the India, then first is always a short title of the act, and second is always definition. When you are reading any act as far as Indian legal system is concerned, first is section number 1 is short title, name of the act, and then second section is always all the definitions which is included as far as the particular act is related. So in the same way, if you look at legal consideration, that is section number 2D, here 2D. Offer and acceptance, which is covered into the section number 3 to 9. Free consent to the party, which is contained section number 13 to 22. Right? And in the Indian Contract Act, if you look at whether the contract is void or voidable, what is the main difference between void contract, which means that void contract means from the beginning, this particular contract is void, null and void kind of thing. It is not enforceable by law. And a voidable contract, which means that when the two party entered into some kind of offer and acceptance kind of a relationship, that time, after knowing that certain facts about the contract, we can say that it is voidable contract. It is not enforceable by law. So that is the nature of the voidable contract. What is the voidable and void contract? Very quickly we will see into the next slides also. But in the Indian Contract Act, when the capacity of the contract, it is covered into under the section number 11. In the section number 11, who is a competent party who can enter into the contract. So that is also described into the section number 11. If you look at the Indian Contract Act, discharge of the contract, the section is covered section number 37 to 67. Right? And breach of the contract is 73 to 75. The remedy for breach of the contract is also into the 73 to 75. Right? So this is the this particular graphical representation. You need to remember, okay, what kind of questions can be asked if it is from the Indian Contract Act, right? Okay. Now another, this is very basic, terminology as far as the Indian Contract Act is concerned. The agreement and the contract. Agreement is nothing but offer plus acceptance, and contract is agreement plus backed by the legal, means legal enforceability. Agreement may create the social or legal obligations. Contract always create legal obligations between the party. All the agreement do not become the contract, but all the contract are based on. Hello. Hello, can you see this particular slide? Can you see this particular slide? Hello. અહીંયા સ્લાઇડ દેખાય છે તમને? સ્લાઇડ નથી દેખાતી? હેલો.
જી સર.
હા.
ખાલી 1 મિનિટ મને આપજો સર.
હા.
જી સર. સોરી સર.
ના ના કઈ વાંધો નહીં.
અહીંયાથી આ ટેકનિકલ ઇસ્યુ છે સર, એટલા માટે.
હા હા.
બીજું ઓપ્શન નથી.
હા હા, મારી સ્લાઇડ છે ને આમ દેખાય પણ મારું જે એવો છે ને કેમેરો નથી દેખાતો એવું કંઈક છે, પણ સ્લાઇડ દેખાય છે મારી. હે ને એટલા હા. અને મેં ચાલુ તો કરી દીધું છે પણ પહેલા જોવે છે એટલે હા હા ઓકે ઓકે.
ચેક કરવા એ તમે કેમ કર્યું?
અહીંયાથી મેં જોતો તો થઈ ગયું અને
ઓટો થઈ ગયું. હું કરીને થાકે. આમાં તમે પેલામાં તમે જુઓ, પેલામાં છે ને આપણું જે ઓબીએસમાં જુઓ.
હવે આ દેખો, આ કેમ તમે કેમેરો ઓન રાખ્યો છે તમારે? તમે હાઈડ રાખવાનું.
ચલો એ થઈ ગયું. હું તો દેખાતો જ નથી, વાંધો નહીં.
ના તમે એમ નહીં દેખો.
હે ને ઓબીએસમાં તમે એકવાર ચેક કરો. તમે કહ્યું એ પ્રમાણે મેં કર્યું ને તો પણ એ કશું આવતું નથી.
આવી તો યોગા થઈ જવું
અત્યારે નહીં, પણ તમે આમાં ચેન્જ કરી
શું?
હા તમે ચેન્જ કરો.
અહીં ગયા
હા
તો આજ જવાનું છે ને?
એ તો મેં કર્યું હમણાં તમે આવ્યા પહેલા.
તો આ આવી તો ગયું.
તો બાય મિસ્ટેક આવી ગયું. હું થાકી ગયો.
આજ કરવા જ
વાંધો નહીં. અરે ફર્સ્ટ ટાઈમ છે એટલે પછી વાંધો નહીં. લાઈવમાં તો લીધું ખબર. જી સર થઈ ગયું સર. ઓકે
થઈ ગયું છે ને? હવે દેખાય છે પીપીટી? ઓકે. Okay, so I'm quickly just going to the previous slide and Indian Contract Act. These are the sections. I'll definitely pass on this particular PPT to the Dharmesh bhai and he will share with you. Okay, but these are the basic element: agreement and the contract. In which what is the difference between agreement? Every agreement is not enforceable. If it is not enforceable by law, then it is not a contract. And there is all the contracts are based on the agreement. That is also one of the truth. And sometimes in the examination it is being asked that concessus ad idem, that is the Latin word which is described in section number 13 of the Indian Contract Act, which is that the meaning by that you need to understand the meaning that the meeting of the mind or the identity of the mind or receiving the same thing at the same time at the in the same sense, which means that it fulfill the contractual elements of offer, acceptance and consent or the capacity of the contract. So that's how you need to remember that. Sometimes into the examination they will ask that what is the meaning of consent ad idem, right? So that is a terminology related to the Indian Contract Act. What are the essential elements of the valid contract? That is described in section number 10. There has to be a valid offer and the acceptance. I can't sell moon to you, which is not the valid offer. So you can able to understand by this example that offer has to be valid, right? Intention to create the legal relationship. When I am party number A and party number B, when they are entering into the contractual relationship, there has to be intention to create the legal relationship. If there is legal relationship is absent, then we cannot qualify them into the contract act, right? Consensus addendum just now I have explained. Lawful consideration, which means that lawful consideration means that there is intention to create the legal relationship under the offer and acceptance. So that is a lawful considerations. Capacity of the contract that we have seen. Free consent means no, both the party which is entering into the contract, they are free consent. Free consent meaning that they are not under the pressures of anybody and they are by their will freely entered into the contract. So that is called as a free consent, right? Legality of the object which has to be legal and which is enforceable by the law. Possibility of the performance. You cannot enter into the contractual agreement which is impossible in nature. Let me give you the example that I want to reach on the sun, inside the sun. So that contract, if I'm making, that kind of a possibility of the performance is not there. So that particular contract is invalid, right? So there is a, and the contract under the Indian Contract Act 1872, the contract it must be into the writing and it is always has to be registration. There has to be registration then, and then this particular contract is valid, right? So that is the element, right? What are the classifications? What are the class? This particular slide will give you the idea about the classifications of the contract, which says that legal effect, performance, and the formations. Legal effect means valid contract, void contract, voidable contract, unenforceable contract, or illegal contract. So that is a legal effect, legal side effect. Performance means when the particular party entered into the contract, whether it is a unilateral contract, bilateral contract, executed contract, or executed, that we will let understand into the next slide. Formation of the contract. Express means written, implied means you have not written into the document but it is implied, and quasi contract, which means the combinations of both express as well as implied, right? So let us understand what is the meaning of those terminology which we have seen into the classifications, right? So let us understand the types of the contract. I'm just touching upon the main fundamentals of the contract so that any questions can be asked, then logically even you can answer, right? Right. So the valid contract, if all the conditions are fulfilled, it is called valid contract. All the conditions are fulfilled, which means that in the previous slide, in the graphical representation which I am showing, that all the condition has to be fulfilled. Invalid contract, which means that in a contract, if any one condition is not fulfilled, any contractual condition is not fulfilled, then that particular contract is invalid under the clause. Void ab initio contract. At the time of the agreement, the contract is not valid from the beginning. A contract is not possible, but still the party has entered into the contract. That kind of a contract is invalid from beginning. Another name of that particular contract is void ab initio. The become void contract, which means that an agreement which is valid in the beginning, but due to the some supervening impossibility, the contract become void. Once the two parties entered into the contract and after performing the contract, there they feel that this particular contract cannot be fulfilled, so that contract is become void. Voidable contract, the contract which is valid unless and until avoided by either the party. So that is called voidable contract. Illegal contract, an agreement which is forbidden by the law. The provision is not described into the law, that is illegal contract. Okay, whatever written into the Contract Act 1872, and the party is entering into the certain kind of illegal activity. For example, in share market, if there is an insider trading kind of a thing, so that is an illegal kind of a business, so that contract is invalid. right? So that is any commissions of the crime, or it violate any policy of the government of India, or that particular contract is immoral in nature, that kind of contract is illegal contract, unenforceable contract. It is a valid, but due to some technical defects, the contracts becomes void. So in case of the defect is removed, the contract is enforceable. Lack of registrations and lack of signatures, these are the critical element as far as the contract is concerned. Based on the formations, express contract means it is into the written form or into the oral form. If it is in the oral form, then you have to prove that this particular contractual obligation has been consented by both the party. Implied contract means the thing is not written nor oral, but it is being implied that this particular is the obligation under the contract to be fulfilled. So that is called the implied contract. Quasi contract means it is not actually entered into by the parties, but something which is imposed on the party by the law. So that is called a quasi contract, right? Based on the performance, the classification, if you look at the classification slide, based on the performance, there are 4 categories, right? I hope you can see unilateral contract, bilateral contract, executed contract, and executory contract. So we'll see, this based on the performance, executed contract, in the contract where both the party have performed their legal obligations and there remain nothing to perform. So that is called executed contract. Executory contract, in a contract where both the parties are yet to perform their obligations. So that is called executory contract. Unilateral contract, in a contract, one party has performed his obligations and other party is yet to perform their obligations. So that is called unilateral contract. Bilateral contract means bilateral. The word itself says that 2 parties. In a contract where both the parties have performed their obligations, that is called bilateral, and executorily are same and it is interchangeable. If you look at this, right, I have given these sections also. In the blue, Indian Contract Act, void and voidable contract, that is covered under section 2J, 19 and 20. Discharge of the contract, which is covered in section number 37 to 67. Remedies of the contract, which is covered in section 73 to 75. If you look at the essentials of the valid contract, that is covered under section number 10, which we have seen, right? Essential of valid contract. If I go back to the slide, essentials of the contract, section number, under the section number 10, we have seen, right? This essential of element of the contract, and this much is covered, right? So that is, we have covered, right? And if you look at the remedies, essentials of the valid contract, where the offer and acceptance, which is covered under section number 3 to 9. And if you look at the essential of the valid contract, that is a free consent, section number 13 to 22, right? So that explanation, I think we, offer, while you are preparing for the examination, then you need to understand this element of the valid contract means which things you need to prepare: offer and acceptance, clear offer, or unqualified acceptance. Lawful consideration, something of the value must be exchanged. Free consent means both the party must agree voluntarily. Capacity of the parties, the party must be competent, not minor. Here I want to add certain things. If you go into the deeper into the legal side, then the contract with the minor is executable. But if it is benefit to the minor, then that particular contract is enforceable by law. That is, law says that. Capacity of the party, any general layman will say that if both the parties are not adult, then contract is invalid. But if you go into the detail of the Indian Contract Act, the contract with the minor is also valid. The condition is that it is into the benefit to the minor, then that particular contract is valid, right? The legality of the object, the contract's purpose must be lawful, right? So that is the idea. Now, if you look at the essential of the valid contract in Indian Contract Act, whatever graphical representations I have showed, and whatever elements here is shown in the yellow color, that we have covered, like capacity of the party, free consent, lawful consideration, offer and acceptance, right? That and this particular free consent is also included. The party must be agreed, so that is also covered under this element, right? Okay. Now I am going to the this capacity of the party. The minor cannot enter into the valid contract, but the condition is that if it is a benefit to the minor, then it is executable contract. Insane or disqualified person, lack of legal capacity, the person who is lunatic kind of a thing, or he is not into the right frame of the mind, or he is bad kind of thing, so they are the party which cannot enter into the contract, right? So that is the idea. Free consent means the undue influence. These are two terminologies important: coercion, undue influence, and fraud and misrepresentations. If you look at the third term, fraud and misrepresentation, which attract the criminal penalties or criminal punishments to the parties. If it is a commercial in nature, then the coercion, forcing someone to enter into the contract, then that contract is invalid under the Indian Contract Act, but it is also punishable under Indian Penal Code and right now Bharatiya Nyaya Sanhita. It is punishable. Undue influence, taking the advantage of the relationship or the power, and the two party entered into the contract, that is also illegal, right? So these are that is not called it. Now in law, free consent means exactly opposite to it: coercion, undue influence, and fraud. These are the enemy of the free consent. So when we are remembering those concepts, that time free consent na je bhi opposite hai, whatever is the opposite, that is not free consent. Coercion is not a free consent. Undue influence is not a free consent. Fraud and misrepresentation is not a free consent. So the questions can be asked into that manner, right? So you need to remember like this, right? Okay. Now this we have covered, right? Coercions, and why I'm just pasting this particular pictorial representation, because we have discussed about the coercion or forcing someone to enter into the contract is not free consent. Fraud and misrepresentation is not a free consent. Undue influence is not free consent. Consent is not free. If it is obtained by this three, it is not a free consent, right? So discharge of the contract, when the contract is completed. So in the discharge of the contract, when you can say that this particular contract is completed. So there are 5 elements: by performance, by agreement here, by impossibility, by breach, by lapse of the time. If you look at the by performance, both the party fulfill their contractual duties, then you can say that the contract is discharged. Contract is about to complete. By the agreement, if both the parties is mutually agreed to the contract, then you can say that the contract is discharged. By the impossibility, the performance is impossible due to unforeseeable event like flood or any kind of a natural calamity or that kind of thing, under which both the party or either of the party cannot fulfill the performance, then also it is discharged, right? By the breach, the parties fails to perform the obligations, so that is a breach of the contract. Lapse of the time, within this stipulated period of time, the contract has to complete it, and if either of the party is not fulfilling the promises, then that contract is discharged, right? So that is a discharge of the contract. right? Now, if the contract is breached, then what are the remedies are available? When the party fails to fulfill their contractual obligations, a breach is occurred, and leading the remedy available to the aggrieved party. Those aggrieved party means the party which are involved into the contractual agreement. So they and one party is dissatisfied, that is the aggrieved party, right? So the key points, what are the types of the breach? Whether it is an actual breach at the time of performance or anticipatory breach before the performance. What is the remedy? Means what is the solutions in under the Indian Contract Act? Then the compensation can be paid, damages can be paid, specific performance can be asked, and the injunction, prohibitions of the actions can be made, right? So that is called it as a breach of the contract. One of the case which, one of the small story which I would like to share with you, that one particular one particular lady has exchanged her watch to her friend, and that particular lady is not returning her watch, wristwatch, and one particular lady claimed that particular contract is being broken. Okay, you know, I have given this particular watch for the use, and the particular my friend is not returning that particular watch to me, and that matter goes to the court, and court has said that we cannot, the court has no jurisdiction beyond the compensation. Compensation means damage जो हुआ है, that particular damage can be compensated by either of the party, because that particular party is not returning to your watch, but it is not the responsibility of the law that that particular thing which is returned to you. So that is also the nature of the contract kind of a thing. I mean, you know, so in that sense, the compensation, when it comes, when the one particular party fails to perform, then the compensation in terms of the money can be paid. It 99% of the cases, actual thing cannot be returned, but compensation can be paid, right? So that is the idea, right? Okay, anyway, next, quasi contract. Quasi contract are the obligations imposed by the law in absence of the contract, usually to prevent the unjust enrichment of the one party. No actual agreement, but the legal enforcement due to the fairness. Example, person receiving the goods by mistake is liable to pay for them, right? So if the any person is receiving the goods by mistakes also, he is liable to return that particular goods to the party to whom it is belonging. He cannot waive away the other persons and write that I do not have that kind of goods with me. Even if he do not have the goods, then he has to pay the compensation, that remedy, compensation maybe, or specific performance can be asked, or injunction can be made, right? So that is the idea. Special contract. This special contract includes indemnity, guarantee, bailment, pledge, agency related contract. And these are the specific type of contract which is mostly used into the commercial applications. The contract of indemnity and guarantee, there is a specific provisions into the act. The contract of bailment and pledge, there is a specific provisions into the act, and there is a contract of agencies that also the provisions into the act is there. The contract of indemnity and guarantee, the indemnity is what? Which involves the one party promises to save another from the loss, while the guarantee is involved by one party, assuming the third party will perform. For example, if I want to send the goods from the train to Delhi and my goods is transferred to the railway, now it is a railway's responsibility, and railway has taken the insurance for the goods also. So that is an indemnity kind of a relationship, because I do not have control over my good. Now I want to send to the Delhi, so it is a responsibility of the railway to reach to take my goods, and it has to be reached to the Delhi and the specific person. In between them, if there is a loss, then it is a liability of the railway as far as my contract with the railway is concerned, because I have given the particular goods to railway department, and railway department has a responsibility to take care of that particular goods. And if the goods is lost or damaged, then they have taken the insurance, that then they will claim for this. So the insurance party is the indemnity kind of thing, right? So indemnity is the party A compensate the party B for the losses is suffered. Guarantee means party A promises to answer for the parties B's debt to party C. So that is a guarantee. Like, you know, when you are purchasing the goods from the store, then they are giving the guarantee and a guarantee kind of thing. So the party A is a promises to answer to answer for the parties B's debt and for party C's, the manufacturer, right? The types of the guarantees: specific guarantee and continuing guarantee. Specific guarantee is related to the specific conditions, and continuing guarantee for a period of time. So that is called continuing guarantee, right? Contract of the bailment and pledge. Most of the questions may be asked, one or two questions may be asked. Bailment. So bailment, where the one party temporarily delivers goods to the another party, while the pledge refers to the bailment for security purpose. Pledge ma, you know, they are keeping for the security purpose only. In bailment, the temporary delivering the goods to another party. So that is a difference. So there is a specific provision in Indian Contract Act related to the bailment and pledge. The bailment is a transfer of good for this specific purpose, maybe the repair or that kind of a thing. Or pledge, the goods are given for the security, like a loan kind of a product, right? So that is a pledge, right? Then agency contract. In the agency contract, you need to understand two terminology. First is a master and the servant relationship. When the master means the main company, and the servant means there are different branches across the India. So master, whatever master company will say, that all the branches has to follow. And the agency, through the agency, the particular company is operating, then he has to follow the rules and regulations provided by the masters. So the agency contract is the relationship between the master and the servant. If the agency fails to perform the contract, then the master is responsible, which means that the main company is responsible. The agent must act within the authority of the master. Master, sometimes called it as a principal servant relationship. So here the principal is bound by the agent sections within the scope of the authority. An agency can be terminated by revocations, death, completions of the agency for the purpose. When the agency contract can be terminated, either revoked, that particular contract is revoked, means the contract is null and void, either of the parties dead, or the completions of the agency, the purpose of establishment of the agency, that particular purpose is completed, then that particular agency contract is null and void, right? So that is we have covered the first part of the syllabus, that is a Indian contract. Now we will look at the Sales of Goods Act 1930. Sales of Goods Act, the Sales of Goods Acts govern the sales and the transfer of the goods. It is only related to the sales and the transfer, and it distinguishes between the sales and agreement to sales. Now let me make you understand what is the main difference between sales and agreement to sales. When you are walking to the shopping street, then there is a display of the clothes, which means that it is not the offer by the shopkeeper, by the shop owner, but it is invitation to offer. In legal language, we say that it is just invitations to offer. And when you are entering into the shop, when you are agreed to purchase, that time, if the buyer want to sell, then that relationship is called as an agreement to sell. So there is there are three steps. One is display of the goods is not for the sale. It is just an invitation to sell. Once you are looking to that particular invitation to sell, you show your interest, talk with the seller. Once he agreed upon, which means that there is an agreement to sell, and then sell will happen. So in the same way, Sales of Goods Act is nothing but sales and the agreement to sales. The sales means what? It is immediate transfer of ownership. Ownership, possession, these two are different things. Ownership means I am owning the particular object. This is mine. But right now it is in my possession. It may happen, I may give my mobile phone to some another person, which means that my goods is transferred to my friend and my ownership remains with me, but only possession is transferred. I hope you understand. There is a difference between ownership and possessions. So if you read the Transfer of Goods Act, Transfer of Property Act, in that particular Transfer of Property Act, it has been very in detail explained which are the conditions of the ownership, which are the conditions for the possession, and which are the conditions for the transfers. Right? Anyway, so we are not discussing that particular Transfer of Property Act as of now, but you need to understand under the, because this goods is also one of the property. So that in that sense, I just want to explain that immediate transfer of ownership means sales is just an immediate transfer of ownerships. Agreement to sales is future transfer of the ownership. You are not immediately transferring. Agreement to sales is related to the future. Sales is immediate transfer of ownership, which applies to movable goods, not to the immovable property. Right? Okay. Okay, I'm not able to upload the PPT. Let me just reopen again this PPT. There are some of the, okay, can you able to see the PPT now? Can you able to see? Okay, Sales of Goods Act, we are at that. Okay. Now in the Sales of Goods Act, this is doctrine. You know, many times the examiner, the paper setter is asked doctrine of caveat emptor. That is the Latin word. What is the meaning of caveat emptor? This doctrine means that let the buyers beware. Let the buyers beware. Buyer must examine the goods themselves and cannot claim the defect afterward. It means that when the buyer is purchasing the goods, it is the responsibility of the buyer to see, examine, make sure that this particular good is competent to buy. Whatever performance this particular good is being created, that particular good is performing that. So that is a caveat emptor. That is a Latin word which means that let the buyers beware. Now, what are the key points into the caveat emptor? The buyer is responsible for checking the quality of the goods. In the exceptionals, if the seller hides the defect, or if the buyers is rely on the seller's skills, on the judgment, then that is an exceptional case. But if the seller is hiding this defect, then under the Consumer Protection Act, the buyer is liable to get the compensation. Right? So what are the right of the unpaid sellers and the buyers under the Sales of Goods Act 1930. Right? So when we are talking about rights of the unpaid sellers and the buyers, when the goods are sold but not fully paid, for the unpaid seller has a certain rights, just as the buyer has the certain remedies. The key point of the unpaid seller's right to lien, stoppage of the tranches. वो क्या कर सकते हैं? You know what they can do? They stop the tranches. With they right to transfer the particular goods to the another party, and they have the right to resell also. So that is called unpaid seller's right. Unpaid seller's right. What are the buyer's right as far as the Sales of Goods Act 1930 is concerned? Then he damages for non-delivery. If the goods is not delivered in the conditions which he is expecting, then he can ask for the damages. Right to reject the goods. Buyer can reject the goods also. And right to specific performance. He will ask that for whatever purpose I have bought this particular product, you have to give me that product. So in the Sales of Goods Act, I think there are very small act. It covers only 30 or 40 sections, right? So when you are reading preparing for this particular Sales of Goods Act, you just need to understand caveat emptor, what are the rights of the seller and what are the rights of the unpaid sellers and the buyers. That is most important, and most of the questions which is being asked from that category, right? Then another act, third, if you look at, I'm going to the second slide of the syllables. I presume you can able to see this. Can you able to see that? So we have covered Indian Contract Act. In the Indian Contract Act, there are two sections. Now we have covered the right of unpaid sellers and right of buyers. Now we are going to the Negotiable Instrument Act, right? So again, what is a Negotiable Instrument Act? Negotiable Instrument Act, which is designed to transfer the particular currency. I think I am not, you are not able to see the particular diagram representations. But let me tell you the object. I'm telling you orally. What is the object of Negotiable Instrument Act 1881? So object of this particular act is to provide the framework for negotiable instrument like check and those kind of things, check, hundis, and DD and those kind of things. So instrument which facilitate easy transfer of money and the credit. Mostly Negotiable Instrument Act, whatever check we are using, that is Negotiable Instrument Act, right? Whatever DD we are preparing, that is Negotiable Instrument, right? RTGS, for the purpose of the RTGS, we are filling up the form, that is also Negotiable Instrument Act. NEFT, when we are doing from the banking, then we are filling up the forms and then the bank is doing the NEFT, that is also Negotiable Instrument. Right now all the forms is digital, but still it is under the IT Act 2000, it is still considered as the negotiable instrument, right? Okay, anyway, so the object of this particular Negotiable Instrument Act is to provide the framework to negotiating the instrument while facilitating easy transfer of money and the credit. What is the purpose of this particular act, Negotiable Instrument Act? It is defined all type of negotiable instrument which outline the process of negotiation and the assignment and stipulated the rights and the liability of the parties which involved into the dishonor of the check and the discharge, right? So that is the negotiable. Let us understand the act govern the negotiable instrument, all the promissory notes, all the bills of exchange and the checks which are essential for the business transactions. What are the key points into the Negotiable Instrument Act? It defines the type of the negotiable instrument, and which ensures the transferability and the payment of the instrument. Now let us understand the types of the negotiable instrument. The promissory note, which is written promise by one party to pay a specific sum of a money to another party, which we call it as a payee, at the specific time or on the demand. And that's why the check period is 3 months. Okay, specific demand. If the particular party is demanded today or after 2 months later, then through the negotiable instrument check, he can demand the money. Example, the personal loan agreement, right? Either I want today, 2 months later, or after 3 months, I can get it. So that is a promissory note. Bill of exchange, which is a written order from one party. That particular party is called as a drawer, and the another party, that is called drawee, to pay a specific sum of the money to the third party, that is called payee, either on the demand or at the future date. So that is called bill of exchange. A trade transactions where the goods are sold on the credit. So that is the example of bills of exchange. Then third negotiable instrument is a check. The return order, which is directing to whom? To the bank to pay a specific sum of the money from the drawer's account to pay upon the presentations. What kind of a presentations? The presentations of the bearer check, which is payable to person who is holding it. Order check, payable to the specific person or on the order. Cross check, that we are doing account pay check, cannot be cash at the bank, but it must be deposited into the bank as an account, right? The types of the negotiable instrument, next after 3, this fourth is a draft, demand draft. Similarly, the bill of exchange, a draft in ordered by one party to another to pay the specific amount. It often involves 3 parties, the drawer, the drawee, and the pay. It's like a traveler's checks. We are paying money to the bank here, we are getting the traveler's check, and we are showing to the foreign country, and foreign country will encash money, and that is a third party. So it is the negotiable instrument in the kind of a relationship of 3 elements: drawer, drawee, and pay, right? Then next negotiable instrument, fifth negotiable instrument, is certificate of deposit, that is called CD, not the compact disc. CD, certificate of deposit. In context of negotiable instrument, it is a certificate of deposit. A time deposit offered by the bank that pay the interest at the fixed rate for a specific period of time. The bank is issuing the certificate as an evidence of the deposit, which is called negotiable. Example, a bank is issuing the certificate of deposit, suppose fixed deposit, CD, that can be transferred to the another party. So that is a credit certificate of the deposit. Now in the Negotiable Instrument Act, the section number 138, which is most important. Probably it may be asked into the examination also because section 138, check bounce. Earlier in those days, the check bounce was not the criminal offenses, but right now under the new amendment, the check bounce is the criminal offenses, which means that if the one particular party is giving check and the another party does not have the balance, then the party can sue into the court of law Okay, you are not maintaining the balance and you are doing fraud with me and your check is bounced. So right now, as of now, under the new amendment to the Negotiable Instrument Act, under section 138 of Negotiable Instrument Act, this is a punishable offense, right? Now let us understand what is the negotiation and the assignment under the Negotiable Instrument Act. The negotiations involve the transfer of ownership of the negotiable instrument by delivery or the endorsement, while assignment refers only to transfer of the right. And if you look at the basic principle from the beginning, what is law? Law is actually protecting the right. It gives the man right. It gives the man to its right. And that's why the law is being enacted. So in the same way, if the nature of the negotiable instrument, which gives the right, which create the right in the assignment, it refers to only transfer of the right, which means that if I am assigning some another person this particular instrument, I am just transferring my right to the another person, right? So that is a difference between negotiations and the assignment. Negotiation creates the right in the transferee, the holder in due course, and assignment transfer the existing right. Right means hak. I mean, in Gujarati we can call it as a hak. So that is, assignment is transfer whatever existing right we have, that particular right is transferred, right? So that is the idea. Now this dishonor and discharge of negotiable instrument. Dishonor occurs when the instrument is not paid or accepted or presented. Discharge of the negotiable instrument releases all the liability, right? If you look at this, dishonor of the check means either the check bounce and those kind of things, and discharge means that particular instrument is not valid for the certain kind of reasons. So dishonor is kind of a failure to pay or accept. For that the notice is required, and discharge is by the payment in due course, the cancellations or the material alteration. So that is called as a discharge. So in the negotiable instrument, you need to understand only the idea of definition and the types of the negotiable instrument act, right? In that the question can be asked. Section number 138, check bounce, dishonor of the check. What is the difference between negotiation and the assignment? That related questions can be asked, right? So these are the things which can be asked as far as the negotiable instrument act is concerned, right? Okay, so if you look at, now I'm going to the course slide second. In that, next topic is this Companies Act 2013. In the Companies Act 2013, I presume that you can able to see the PPT. Okay, let us understand. Companies Act 2013, the law is regulating the companies. Now, if you read the section number 2 of the Companies Act, what is company? Then it is very simple definition which follows the Companies Act 2013, and which is created under the Companies Act 2013, that is called company. They are very simple definitions. But what is the company? The company is a group of the people. I mean, I'm going into the organization behavior definition kind of thing. In the organization behavior, we can say that the company is a group of the people, and group of the people are together for completing the completion of the certain task, which is nothing but the organization's goal and which is beneficial to the entire organization. So that's how we can form the company. But that definition, but the legal definition is the company which is formed under the Company Act 2013, that is called company under the section number 2, right? So that is a definition, but you need to remember that where the definition is given, company's definition is given, then it is under section number 2, right? Okay. Anyway, the you can see the law. What is the purpose of the Companies Act, and what is the object of the Companies Act? So I'm just I'm not I'm just telling you the object first, to regulate
Okay,
the.
sir. Sorry, sir. Sorry to disturb you. Dr. Ransaria is here.
Sir.
Okay, sir. Actually, I was very busy in the youth festival today in my university.
Okay.
So sorry,
No issues, sir.
Not any welcome you in the initial stage of this session.
No issues, sir. No issues. No issues.
If you don't mind, I will take just 1 minute right now.
Yeah. Please, sir. Please, sir.
Okay. Yes, dear students. હું લેટ આવ્યો છું એ બદલ આપની માફી માંગુ છું. ફરીથી એક વખત હું વિદ્યાર્થીઓને તો આવકારું છું, પણ સાથે સાથે આજના જે એક્સપર્ટ છે આપણા ડોક્ટર પ્રશાંત અમીન સાહેબ, જેને તમે છેલ્લા 1.5 કલાકથી સાંભળી રહ્યા છો, અને એ તમારી સાથે લીગલ આસ્પેક્ટ ઓફ ની ચર્ચા કરી રહ્યા છે, જે આપણું મહત્વનું 9મું યુનિટ છે. તો સાહેબનો જે પરિચય હું તમને બહુ મોટો પરિચય છે, વિશિષ્ટ પર્સનાલિટી ધરાવે છે, એમનું જે એરિયાસ છે કોર એરિયા એ પણ એટલા બધા છે કે એની ડિગ્રીઝ તમે જોવો તો ખૂબ મોટી વિશાળ શૈક્ષણિક લાયકાતો ધરાવી રહ્યા છે. ખાસ કરીને સાહેબે BA ઇન મિકેનિકલ એન્જિનિયર તરીકેની ગ્રેજ્યુએશનની ડિગ્રી મેળવી, ત્યાર પછી LLB કરેલું છે, MBA ની એટલે કે મેનેજમેન્ટની ડિગ્રી ધરાવેલ છે, PGD FM, PGDI IPM ની ડિગ્રી છે, LLM છે, PhD છે અને UGC નેટ. આ સિવાય સર્ટિફિકેટ કોર્સ છે, સાયબર લો ઇન ગુજરાત નેશનલ લો યુનિવર્સિટીઝની પણ ડિગ્રી છે. એટલે આમ તમે જોવો તો મલ્ટી પર્સનાલિટી છે કે જેમના એરિયાસ છે એ એટલા બધા અલગ અલગ છે કે જેવા વક્તા આજે આપણને મળ્યા છે ખાસ. તો આવી વ્યક્તિ આજે આપણી સાથે છે અને એમનો કોર એરિયા છે લીગલ આસ્પેક્ટ. તો લોની જ્યારે વાત કરવાની હોય તો આનાથી વિશેષ વ્યક્તિ આપણને ક્યાં મળી શકે? તો સાહેબ જે હાલમાં MS યુનિવર્સિટીની અંદર આસિસ્ટન્ટ પ્રોફેસર તરીકે કામ કરી રહ્યા છે, અને હું MS યુનિવર્સિટીનો ખૂબ આભારી છું કે આ અમે જે મહાયજ્ઞ શરૂ કર્યો છે Gset ની અંદર, એમાં મને મારા તમામ MS ની અંદરથી જે વક્તાઓ છે, સારા સારા વક્તાઓ મને મળી રહ્યા છે. જસ્ટ અ મિનિટ. ઓકે. તો એમાંના એક સારા વક્તા લીગલ આસ્પેક્ટની અંદર આપણી પાસે ડોક્ટર પ્રશાંત અમીન સાહેબ છે. સાહેબ, ઓન બિહાફ ઓફ માય university, on behalf of Vice Chancellor of my university, Dr. Pratap Sri Chauhan Sahib, on Registrar of my university, Anil Solanki Sahib, on Department Head and my Guru, Professor Daksha Pratap Sri Chauhan Madam, and on my personal behalf, sir, I heartily welcome you, and I also very thankful to you for this session, sir. Yes, all to you, sir.
Thank you, sir. Thank you so much, sir. Thank you so much, sir.
Sir, more request, just a minute. And sir, when you want to complete, just you can complete the session. My technical tab is there. Just you inform. They will close the YouTube live also, sir.
Okay, sir. Sir, just I'll cover this one particular slide and then I'll rest my speech, because if I'll just I have started, that's why.
Okay, sir. No issue, sir.
And other second portion I'll cover tomorrow.
No issue, sir. Thank you. Okay, sir. Thank you very much.
Okay, sir. Thank you so much for the good introduction, sir. You have portrayed me as a on the sky, but I am not on the sky. I'm very much on the earth. Thank you so much, sir.
No, thank you, sir. Thank you.
Okay. So we are talking about the companies. The company is, as I said, that in the organization behavior, the definition is different. A group of the people coming together, fulfilling the organization goal. So that's how the company is being created. But under the section number 2 of the Company Act, company kone kehvaye to bhai company is the under the Company Act je company registered thayi hoye, that is called as a company, right? So earlier when we are the student, we have the Company Act 2000 1956 we have studied, but right now the Companies Act 2013 is there. There are certain modifications, and if you go to the skeletal of the Companies Act, then there are various definitions related to the formations of the company, okay, how the company can be formed, what is the article of association, what is the MOA, memorandum of associations, how the company can be governed, what is the corporate governance aspect, company ને કેવી રીતે ચલાવવાની હોય, કેટલી meeting હોવી જોઈએ, what are the annual general meetings, and public meetings, and everything is being covered as far as the Company Act is concerned. And company is a legal entity, and it is treated as the legal person, artificial person, and artificial person, but person is not the has certain rights, but company can never do the fraud to the another person, but the managing director, who are the brain of the company, they can do the fraud with the another. So that's how the main conceptual part has been built up, right? So the company is an artificial person, and that particular artificial person is protected under the law, but the company is a unique entity in which the company cannot be prosecuted, but their brains, which means that the board of directors and the chairman and the managing director is prosecuted. And there is one beautiful concept, the lifting of the corporate veil, lifting of the corporate veil. And that particular, how you will identify who is responsible for doing the fraudulent activity with me, then if I am lifting the corporate veil, which means that પડદો હટાવો, lifting of corporate veil, which means હું જ્યારે પડદો ઊંચો કરું ત્યારે મને ખબર પડે કે this particular person who are the brain of the company, managing director, chairman, those are the people who are responsible for doing the fraud. There are many companies which are doing fraud. For example, there are inferior kind of goods some certain companies are selling. And when you are challenged into the court of law, which means you are prosecuting to the company indirectly, but you are actually prosecuting to the person who is governing the company, who is the brain of the company. So that is a conceptual part of the Company and Companies Act. Anyway, let us understand what the law related to the Companies Act 2013, which regulate the formations of the company, which means that how the company which is being created, there are certain sections. What is the operation, how the company can be governed, what are the government compliance to be fulfilled, government ને કઈ કઈ વસ્તુ આપણે બતાવી પડતી હોય, Ministry of External, Ministry of Company Affairs, MCA, there are certain things a company has to liaison with. So that is the operational part. And when the dissolutions of the company, our dissolutions of the company, that is, for that there is another act, આપણા કોર્સમાં નથી, but that is called the bankruptcy and liquidation code, bankruptcy and liquidation code 2016. હવે એ આપણે ભણવાનો નથી, but dissolutions of the company in India, and which is ensuring the corporate governance. Corporate governance means how the company can be governed into the positive manner, which is not cheating, which is doing the business of cheating with the client or the customers or the person to whom the company is dealing with, right? So that is the Companies Act 2013, which has the main object is this. And what are the key points in the Companies Act? The formation, the forms of the company. In the forms of the company, there are public company, private company, one person company, HUF, Hindu Undivided Family, LLP, then sole proprietorship, cooperative company, which is under the Indian Cooperative Act 1932. So there are many forms of the companies, right? There are certain NGOs which we cannot call it as a company, but it is the formed under the special act, non-governmental organization, which they do not have the motive of the profit, but they are also treated as the particular non-governmental organizations. An organization is nothing but in a layman's language, it's company, right? Anyway, so the classification of the company, public, private, and 1%, the main aspect I have written. Then define the incorporations of the company, which means that how the company can be formed, what are the procedures to be followed while forming the company, and what is the formal procedure. So the company formations, there are first document which is being created, The process of forming the company includes the various steps like registration of the company, filing of the document, and complying with the registered of the company. There are key points: the MOA, Memorandum of Associations, and the Article of Associations. એમાં બધું જ defined, everything can be defined in memorandum of association. Can be who is the owner, where is the office, and which are the independent director, dependent director, who will govern who's, where the plant is, where is the register office, and everything, right? So that is also dependent. Memorandum of association and article of association are the two main documents through which the company is formed, and mandatory registrations with the registrar of the company has to be there. So I think today I'll cover up to this. Tomorrow we'll start with the management meeting and winding ups, right? I think if you have any questions, then you can ask me. Right now I can able to give you the answer. If you have any query, then you can unmute and tell me, or you can contact me on my email. But today, let me quickly summarize that how much we have covered as far as our syllabus aspect is concerned. Then this is your syllabus and Gset syllabus, and we have covered Indian Contract Act 1872, under which the special contract and indemnity guarantees, contracts, bailment, free consent, discharge of contract, breach of contract, right? We have covered the Sales of Goods Act 1930. We have covered Negotiable Instrument Act 1881. The Companies Act just we have started. So 1, 2, 3, 4, 5 act we have covered today. Next 5. 1, 2, 3, 4, 5, 6. Tomorrow we'll cover 6 act, right? So with this, if you do not have any questions, then I can rest my voice, rest my speech, and tomorrow we are meeting at 2 for the same, right? Thank you so much. Have a nice day, and thank you for the patient hearing. If you have any query, then you can give me the message on the YouTube live also. I'll reply the query on that, or you can write down, you can jot down my email address, that is dr.prashant.amin, dr.prashant.amin@gmail.com, right? Okay, thank you so much. Thank you so much.
Thank you, sir.
Thank you. Okay.